So from this point we can start. Yeah. Okay, sir. The seventh question is basically recognition. Basically, what are the once you recognize a state, what are the kinds, consequences, de facto and de jure options that are available? So, what does recognition mean? Recognition in international law is a unilateral political act by a state with significant legal consequences, whereby it formally acknowledges the existence of one state. The legitimacy of new government is in an existing state or a particular factual or legal situation. For example, there is a belligerency, insurgency, national liberation movements, or territorial changes. Recognition is crucial as it often determines the capacity of the recognized entity to engage in international relationships, exercise rights, and incur obligations on one place on the international plane with the recognizing state. So the problem is, when do we recognize ante oka particular piece of land as a new state? It might be due to many other reasons like insurgency ఉండొచ్చు, national liberation movements also, territorial changes also. For example, Baluchistan, which is fighting within Pakistan. So what happens if somebody recognizes? What happens if US recognizes it or India recognizes it? Then they'll have exercising rights and they can incur obligations and things like that. So what are the theories of recognition? There are two theories based on which the international law works. One is the constitutive theory. It means that maintains the recognition by other states is a necessary precondition for the creation of statehood or the status of a new government. For example, an entity doesn't become a state or a government doesn't gain international standing until it is recognized. So, and critique leads to practical difficulties and gives existing states excessive power over the emergence of new states. So basically, for example, let's say Pakistan నుంచి Bangladesh separate చేసాము. చేసినాక the fact is everybody has to recognize it as a separate state, Bangladesh separate state, and it has to be recognized by other states also, so that they get membership in United Nations. So that is important thing, because any guy who is supporting Pakistan will obviously say no, it is still part of Pakistan, it cannot be a new country. So how do you manage that? How do you get the necessary support of other states, which is basically is what is the constitutive theory. So if most of the states are saying yes, then it is recognized. The other one is declarative theory. Maintains the recognition merely a formal acknowledgement of already existing factual situation. An entity becomes a state when it meets the criteria of statehood: territory, permanent population, government, capacity to enter into relation with other states as per Montevideo Convention. Recognition simply declares or acknowledges this existing fact. This theory is more widely accepted in contemporary international law and practice, though the political art of recognition remains vital for practical international engagement. The second one is simply they just declare that we are a new state, and we are a new state because based on the territory or the population that have been living from a long time, or the government capacity, okay, to enter into relationship and things like that. So they are just saying, okay, it's a formal acknowledgement of an already existing factual situation. So these are the two theories, constitutive and declarative theories. And what are the kinds of recognition? First is recognition of states. Acknowledges that an entity meets the criteria of statehood.
Declarative theory example cheptara? An idea? Is it like
declarative theory? As simple as Israel, sir. they just went there and they just declared that because our people are here, we want this place, and we are a country now. So, no, good question. Maybe can do some research later and only we can look into it, sir. నాకైతే ఇజ్రాయెల్ అనే అనిపించింది.
లేదంటే ఇప్పుడు ఆఫ్ఘనిస్తాన్ తాలిబాన్ గవర్నమెంట్ వచ్చేసి ఫార్మల్లీ దే డిక్లేర్డ్ దెమ్సెల్ఫ్, రైట్? ఇస్ ఇట్
కరెక్ట్?
This comes under it.
అంటే యాక్చువల్లీ డిక్లరేటివ్ థియరీ అంటే ఈవెన్ తైవాన్ ఈజ్ ఆల్సో లైక్ దట్, రైట్? బెస్ట్ ఎగ్జాంపుల్ ఈజ్
I
ఐ
think
థింక్
that's the
తైవాన్.
right example.
సో మేము సపరేట్ బై, మీరు ఏమైనా చేసుకో. యా, okay sir. So we'll move to the next one. Kinds of recognition. So one is recognition of states. Acknowledge that an entity meets the criteria of statehood under international law, possessing international legal personality. Example, recognition of South Sudan after its independence in 2011. This is generally considered irrevocable once granted de jure. అంటే ఒకసారి అయిపోయింది, మళ్ళీ you can't revoke it. Then recognition of governments. Acknowledge that a particular regime has effective control over state and its legitimate representative. This doesn't affect the recognition of state itself. This can become contentious when the government comes to power through unconstitutional means. Example, the varying international responses to Taliban regime in Afghanistan. Many states engage with Taliban at a practical level without granting formal de jure recognition to their government. Some states have adopted the Estrada Doctrine, formally abandoning the practice of recognizing governments, instead focus on maintaining or severing diplomatic relations as a sign of approval and disapproval. So, మీరన్న తాలిబాన్ ఎగ్జాంపుల్ ఇందులో వచ్చింది. And the third one is recognition of belligerency and insurgency. Acknowledges that the armed conflict with the state had reached a certain threshold of intensity and organization, confers certain international rights and duties on belligerent insurgent group, application of law of war, and imposes neutrality obligations on recognizing state. This is rare and usually provisional. సో బేసికలీ ఫర్ ఎగ్జాంపుల్ బాగా ఎక్కువ ఇన్సర్జెన్సీ అయినప్పుడు ఇంటర్నేషనల్ కమ్యూనిటీ విల్ ఇంటర్వీన్ అండ్ గివ్ దెమ్ సమ్ సర్టన్ ఇంటర్నేషనల్ రైట్స్. ఓకే, సో బెలిజరెన్సీ ఇన్సర్జెన్సీ అంటున్నారు, దే విల్ నాట్ కాల్ ఇట్ మిలిటెన్సీ కైండ్ ఆఫ్ థింగ్స్. And what are the different forms of recognition? So first ఏంటంటే we have studied the theories, kinds, and then now we are studying out modes and forms of recognition. First is de jure. De jure recognition and a full legal definitive recognition, indicating that recognizing states consider that entity to have meet all requirements of legitimacy and permanently. It implies a willingness to enter into full diplomatic relation, acknowledges all legal consequences, generally considered irrevocable. So de jure recognition ఇస్తే మళ్ళీ అదని రీవోక్ చేయలేం. It is like a full and final recognition which gives the legitimacy permanently. And de facto recognition, provisional, temporary, or limited recognition, often based on practical reality that an entity exercises effective control over a territory, even if its legitimacy or long-term sustainability is uncertain. Has fewer legal consequences. The de jure recognition can be than de jure recognition, and de facto recognition can be withdrawn. Allows for practical dealings without conferring full legitimacy. Next is express recognition, occurs through a formal statement, declaration, or official communication explicitly stating the intent to recognize. Then implied recognition, deduced from the conduct of states, such as establishing formal diplomatic relationships, concluding bilateral treaties, or formally accrediting diplomatic representatives. Courts and states are generally cautious about inferring recognition without a clear intent. And then conditional recognition, recognition granted subject to fulfillment of certain conditions by recognized entity, historically used by controversial as it can be seen as interference in domestic affairs or an abuse in the recognized power. The other one is collective recognition, recognition by a group of states or through an international organization. Admission to the United Nations is strong evidence of statehood and often treated as form of collective de jure recognition by member states voting in favor, at least regarding the entity's capacity be a united member. So basically, there are 6 types: de jure, permanent, de facto, temporary. Express recognition occurs through formal statement, declaration. Implied, based on the behavior on establishing relationships, concluding bilateral treaties, or formally accrediting diplomatic representatives. The other one is conditional recognition, recognition granted subject to fulfillment of certain conditions by recognized entity. Okay, go. Astro, go. Astro, I'm on a call. Go. Go. Okay. Sorry, sir. So basically, there are 6 recognition types. The other one is what are the consequences of recognition, especially de jure. So somebody, if you recognize somebody in de jure, what are the consequences of doing it? Which is basically de jure అంటే పర్మనెంట్ కదండి. సో పర్మనెంట్ చేసినప్పుడు వాట్ ఆర్ ద కాన్సిక్వెన్సెస్ దట్ వీ మైట్ హ్యావ్ టు ఫేస్. First is international level, establish diplomatic relationships and allow for exchange of diplomatic missions, enables the conclusion of treaties between recognition entity, confirms a recognized state government's right to sovereignty, territorial integrity vis-a-vis the recognizing state, grants the recognized government privileges and immunity under international law and is related with recognized state. Domestic level ఏంటంటే grants the recognized state government locus standi in the courts of recognized state, allows its law and official acts to be given legal effect, confers sovereign immunity upon the recognized state and is property before domestic courts. సో ఇంటర్నేషనల్ లెవెల్స్ ఏంటంటే డిప్లొమాటిక్ ఛానల్స్ ఓపెన్ అవుతాయి, టెరిటరీ సావరెనిటీ ఇంటిగ్రేట్ చేస్తారు. డొమెస్టిక్ లెవెల్లో లోకల్ స్టాండింగ్, ద రైట్ టు బి సూడ్ ఇన్ ద కోర్ట్స్ ఆఫ్ రికగ్నైజ్ స్టేట్, allows its locals and officials to be given legal effect, confers sovereign immunity upon the recognized government and its property before domestic courts. Non-recognition may prevent the establishment of diplomatic relationships, may lead to non-enforcement of laws and act of unrecognized entity with the non-recognizing state. So these are the consequences, 3 consequences of international, domestic and non-recognition. So the relevant cases, there are 2 cases. One is Luther versus Sagor. This is an interesting case. Luther, a British citizen, basically had a timber factory in Russia, but the Soviet decree in 1918 had said that the timber factory belongs to the government. And later the government sold the same timber factory to another British company called Sagor. Luther sued Sagor in English courts for return on the timber, arguing that the Soviet decree was invalid and UK had not recognized the Soviet government at the time of initial judgment. So because both are US British citizens, Luther actually sued the Sagor company, saying that the Soviet government at that time was not recognized by UK and hence the decree was invalid and he wants his company back. So basically the High Court ruled in favor of Luther, holding that since the UK has not recognized the government, its decrees had no effect. Appeal ruling ended. Before the appeal, the UK government granted de facto recognition to the Soviet government. So they only gave a de facto recognition of the Soviet government, but not de jure. The Court of Appeal reversed the earlier decision, stating that a recognition, even de facto, later extended by de jure recognition, is retroactive in its effects, validating the acts of recognized government from its inception. Therefore, the Soviet government decree was deemed valid. Okay. ఫస్ట్ డిఫాక్ట్ ఇచ్చారు, తర్వాత డిజ్యూర్ ఇచ్చారు. డిజ్యూర్ ఇచ్చినప్పుడు వాళ్ళ ఆర్గ్యుమెంట్ ఏంటంటే సిన్స్ ఇట్ ఈస్ ఎ డిజ్యూర్ రికగ్నిషన్ దెన్ ఇట్ ఈస్ రెట్రోయాక్టివ్ ఇన్ ఇట్స్ ఎఫెక్ట్. హౌఎవర్ this retroactive classic illustration of retroactive effect of recognition on the validity of foreign registration executive acts, it highlights the legal consequences shift significantly post recognition. So basically initial ruling ఏంటంటే the initial ruling, the High Court ruled in favor of Luther, holding that since the UK had not recognized the Soviet government, its decrees had no legal effect in English courts. But later it went to an appeal. But in the appeal, what they said is the UK government initially gave de facto recognition and then it gave a de jure recognition. So the de jure recognition is retroactive in its effects, validating the acts of recognized government. Therefore, the Soviet national decree was deemed valid, and Luther didn't get the company. So this is a classic illustration of recognition. Basically, what happens is when initially you do de facto recognition and then you do de jure recognition, there is a retroactive effect of recognition that comes into effect. So you have to be careful with it when you are dealing with this. So this is a particular unique case in that perspective. Sir, any questions on that?
No, sir. It's clear.
Yeah.
The first వాడికి వచ్చేసి since it was not recognized అని అన్నారు, but when they de-jure recognition is completed for Soviet, so they decided it's going to be retroactive and the previous action kuda is implemented.
Correct, sir, correct. It's a interesting thing because de jure లో పర్మనెంట్ అంటున్నారు కానీ రెట్రోయాక్టివ్ ఎఫెక్ట్ ఆఫ్ రికగ్నిషన్ కూడా కిక్ ఇన్ అవుతుంది, which is an important.
That's the main topic, sir. Retroactive ga.
అవును సార్, అవును. So that's why we highlighted this case. The other one is Tinaco arbitration, which is basically Great Britain versus Costa Rica, 1923. The Tinaco regime came to power in Costa Rica via a coup in 1917, but was ousted in 1919. The restored government nullified obligations incurred by the Tinaco regime towards British corporations, arguing Tinaco was unrecognized government. Great Britain has not recognized the Tinaco regime. Issue was the Tinaco regime, despite its unconstitutional nature and lack of recognition by some states, a de facto government whose acts bound Costa Rica. So the arbitrator held that non-recognition by other states does not itself invalidate the acts of the government that maintained effective control over the territory and conducted state affairs. The Tinaco regime was found to be a de facto government, and thus Costa Rica was bound by its obligation unless those obligations were contrary to Costa Rican law at the time they were made. So significance supports a declarative theory of recognition and emphasizes that effective control is key criteria of government's action to validity, irrespective of formal recognition by other states. సో ఇందులో ఏంటంటే ద ఆర్గ్యుమెంట్ ఇస్ టినాకో రెజిమ్ 2 years రూల్ చేసినప్పుడు బ్రిటిష్ గవర్నమెంట్తో వాళ్ళు సైన్ చేశారు. సో ద ఆర్గ్యుమెంట్ వాజ్ బ్రిటిష్ గవర్నమెంట్ డిడెంట్ ఈవెన్ రికగ్నైజ్ ఇట్ యాజ్ అ de facto గవర్నమెంట్. సో వన్స్ de facto గవర్నమెంట్గా కూడా రికగ్నైజ్ చేయనప్పుడు వాళ్ళ అగ్రిమెంట్స్ ఇన్వాలిడ్ అన్నారు. బట్ ద రూలింగ్, the arbitrator said that just because other states doesn't recognize, it doesn't become an not a de facto government avadu. It is a de facto government, and because it is a de facto government, so all the obligations will stand unless their obligations are against the Costa Rican law. So in this case, I think the arbitrator went with a declarative theory of recognition, and then what he emphasized is the effective control. ఎఫెక్టివ్ కంట్రోల్ మీకు కంట్రీ మీద ఉండి మీరు లాస్ క్రియేట్ చేస్తే అది ఆనర్ చేయాలి అని చెప్పారు. సో వాట్ ఆర్ ద కీ ప్రిన్సిపల్? డిక్లరేటివ్, ఐ మీన్ జస్ట్ అగైన్ summarizing, declarative versus constitutive debate. While recognizing a political act, the declarative theory is more widely accepted than the constitutive theory. Political act with legal consequences. Recognition remains a discrete act of states, often influenced by political considerations. Effectiveness as a core criteria. De facto control is a crucial factual bias for any form of recognition, especially for governments. De jure versus de facto distinction. De jure is final, de facto is provisional. Retroactivity. De jure recognition has a retroactive effect. And UN membership. While not a substitute for individual state recognition, UN admission is a strong evidence of statehood and functions as a form of collective acknowledgement. So that's what it is, sir. So the next one is basically the International Court of Justice. Basically, you have to remember one thing. Exam law, there is something called ICC and ICJ. ఇంటర్నేషనల్ క్రిమినల్ కోర్ట్ ఒకటి ఉంది, ఇంటర్నేషనల్ కోర్ట్ ఆఫ్ జస్టిస్ ఒకటి ఉంది. ICC deals with individuals. ICJ deals with states.
Okay.
ఓకే. సో, కన్‌ఫ్యూజ్ అయ్యి రాయకూడదు. ఐసీసీ గురించి రాసేసాం అనుకోండి ప్రాబ్లమ్ అయిపోద్ది. సో,
ఐసీసీ డీల్స్ విత్ పర్సన్స్ అంటే ఇప్పుడు
క్రిమినల్ కోర్ట్ కదా సార్ అది.
irrespective of countries, if somebody wants to file a case on a foreigner, they goes to ICC.
కరెక్ట్.
But if a country represents, then it goes to ICJ.
ఐసీజే.
Okay.
డిస్ప్యూట్స్ బిట్వీన్ స్టేట్స్ ఉంటాయి కదా సార్.
Yes.
సో దట్స్ వాట్ ఇట్ ఈస్. సో ఐసీజే పవర్స్, ఫంక్షన్స్ అండ్ జ్యుడిస్డిక్షన్ 2 times అడిగారు. లాస్ట్ ఇయర్ అడిగారు, ఆ ముందు ఇయర్ కూడా అడిగారు ఆగస్టులో. ఆగస్ట్ అయిపోయింది కాబట్టి we should say September. The International Court of Justice is the principal judicial organ of United Nations. It was established by Chapter 14 of UN Charter and operates pursuant to the statute of the ICJ. The ICJ main role is to decide legal disputes that are submitted it to by states and to give advisory opinions on legal questions which are submitted to it by authority bodies of UN organs and specialized agencies. Okay, ఒకటి disputes between states. Second, it acts as advisory for United Nations and its specialized agencies and bodies. The ICJ is central to UN's aim to promote international peace and develop international law by applying and interpreting international legal standards. First one is composition and organization of the court. As per Article 2 to 18, what does the court compose of? The court is organized to ensure independence, expertise, and a balanced representation of the world. Total number of judges, the court is made of 15 independent judges, meaning they serve as individuals and not on behalf of their individual states. This allows judges to be impartial. Term judges are elected for 9-year term and judges can be re-elected. Election process, judges are elected by United Nations General Assembly and United Nations Security Council by separate simultaneous ballots. Candidate must receive an absolute majority of votes in each organ. Qualifications, must have a high moral character and have either the judicial status in their national legal systems for appointment of to the high courts or recognized as juris consult in international law. హై మోరల్ క్యారెక్టర్ వాళ్ళ కంట్రీలో బాగా పనిచేసిన ఆయన కావాలి. Principle of representation, the makeup of the court must represent the main forms of civilization and the primary legal systems of the world. The limitation of nationality, an absolute rule under Article 3 of statutes is that no two judges could be of the same nationality. So if 15 judges, no two judges can be of the same nationality. So this is what is the composition. సో జనరల్ అసెంబ్లీ యునైటెడ్ కౌన్సిల్ అబ్సల్యూట్ మెజారిటీతో గెలవాలి, అంటే ఒక ఓటు నో అన్న వాళ్ళు తీసుకోరు అన్నమాట. And then jurisdiction of ICJ. The jurisdiction of ICJ is fundamentally consensual, meaning states must agree to submit themselves to the appellate authority of ICJ, either explicitly or implicitly, for the dispute to be heard. This consensual nature respects the principle of state sovereignty, which is a foundational characteristic of law of nation. Jurisdiction can be divided broadly into two primary areas. One is contentious jurisdiction. Contention jurisdiction, Article 36 states basically is essentially the jurisdiction of ICJ to adjudicate legal disputes between two sovereign states. It is imperative to note that individual international organization or any entity outside the scope of the state action would not be standing to bring the matter to ICJ in its contention jurisdiction. Modes of state consent. Consent of state, which is the basis or foundation of contention jurisdiction, could be given in a number of ways. One is special agreement, compromise. Two or more states who have existing dispute agree to submit the dispute in ICJ in a special agreement or compromise, Article 36(1). This is clear ad hoc example of consent for a specific case. Compromissory clause in treaties. Many bilateral and multinational treaties include phrased compromissory clauses. Such clauses include the dispute concerning the interpretation or application of particular treaty may be submitted to ICJ for resolution. The second is optional clause declaration. States under declaration that must recognize compulsory ipso facto and without special agreement the jurisdiction of the court in relation to any state accepting the same obligation. This creates a purely reciprocal basis for the exercise of jurisdiction, in that the court's jurisdiction only tends to be those states who have accepted it under similar declaration and subject to respective declarations, which may have exceptions or reservations. So basically, ఇది ఏంటంటే we can only go to ICJ when both the countries are willing to go. ఒక కంట్రీ వెళ్ళి ఇంకో కంట్రీ వెళ్ళకపోతే ఐ డోంట్ థింక్ ఇట్ బికమ్స్ ఎ డిస్ప్యూట్. స్టేట్స్ అండర్ రికగ్నిషన్ దట్ రికగ్నైజ్ యాజ్ కంపల్సరీ ఇప్సో ఫ్యాక్టో అండ్ వితౌట్ స్పెషల్ అగ్రిమెంట్. ఓకే, బట్ ద స్టేట్స్ హ్యావ్ టు యాక్సెప్ట్. ఇన్ సమ్ కండిషన్స్ ఇఫ్ మల్టిపుల్ స్టేట్స్ ఉన్నప్పుడు స్టేట్స్ హూ హ్యావ్ యాక్సెప్టెడ్ గో అండ్ the states who have not come may have their reservations and exceptions. మేము రాము, మేము ఇది చేయము అని వాళ్ళు చెప్పొచ్చు. In that case, the court's jurisdiction only tends to those states who have accepted it under similar declarations. The third one is forum prorogatum. This situation is when a state, when formally or with a treaty obligation, implies its consent to court's jurisdiction by their conduct during the proceedings, such as voluntary not raising any formal objection and participating in merits phase. Okay, so let's say they don't have treaties.
ఇది అంటే ఆప్షనల్ క్లాజ్ డిక్లరేషన్కి వచ్చేసి అంటే ఇది స్టేట్స్ అండర్ డిక్లరేషన్ దట్ రికగ్నైజ్ యాజ్ కంపల్సరీ అంటే ఓన్లీ దే హూ హ్యాస్ డిక్లరేషన్ ఉంటేనే ఆర్ దే ఎలిజిబుల్ హియర్ ఆర్?
So what they're saying is states will recognize as compulsory ipso facto and without special agreement the jurisdiction of course in relation to any others accepting the same obligation. సో బేసికలీ ఏంటంటే ఆప్షనల్ క్లాజ్ ఉండాలి. ఫర్ ఎగ్జాంపుల్ ఇందాక మనం అనుకున్నాం కదా సార్, ఇప్పుడు ఐసీజే వాళ్ళు రాస్తారు అగ్రిమెంట్లో అని. ఒక అగ్రిమెంట్లో ఇంటర్ప్రిటేషన్ చేయడానికి మనకి ఇంటర్ప్రిట్ కానప్పుడు కాంప్రమైజరీ క్లాజ్ అని రాసుకుంటారు, రైట్?
ఓకే ఓకే.
సో లెట్స్ సే దోస్ క్లాజెస్ ఆర్ నాట్ దేర్ అండ్ ఆ క్లాజెస్ ఉన్న స్టేట్స్ మైట్ సే ఉన్నాయి కానీ మేము రికగ్నైజ్ చేయము. ఇప్పుడు వాటర్ ఇష్యూ ఉంది సార్, మల్టిపుల్ స్టేట్స్ ఉన్నాయి, అందులో 4 or 5 స్టేట్స్ ఉన్నాయి. సో అందులో ఏంటంటే సరే ఈ క్లాజ్ లో మనం ఐసీజేకి వెళ్ళాలని రాసుకోలేదు, కానీ 2 స్టేట్స్ వెళ్ళిపోయాయి ఐసీజేకి.
ఓకే ఓకే.
మిగతా 3 స్టేట్స్ ఆర్ నాట్ కమింగ్. సో దే హ్యావ్ ద రైట్ టు కమ్, ఎందుకంటే క్లాజ్ లేదు కదా. సో దే కెన్ సే ఇట్ ఈస్ మా రిజర్వేషన్, మా ఎక్సెప్షన్ విల్ నాట్ కమ్.
Okay, so that can come under ICC jurisdiction or not?
బట్ ఎవరైతే వెళ్ళారో వాళ్ళది ఐసీసీ జ్యూరిస్డిక్షన్ కింద వస్తుంది అంటారు.
ఓకే ఓకే, ఎవరు వెళ్ళలేదో వాళ్ళది సంబంధం లేదు.
ఎగ్జాక్ట్. సో వాడు కోర్టు కూడా ఇప్పుడు 4 కంట్రీస్ ప్రాబ్లమ్ సాల్వ్ చేయాలంటే మేబీ ఇద్దరిదే సాల్వ్ చేస్తాడు, మిగతా వాళ్ళని ఇంకా ఇఫ్ హీ క్యాన్.
yes okay okay fine sir, please.
Sir, thank you. So the fourth one is forum prorogatum. This is situation when a state, whether formally or with a treaty obligation, implies its consent to court jurisdiction by their conduct during the proceedings, such a voluntary not raising any formal objection in particular and participating in the merits phase. Basically this is where the given consent implies. So basically situation when formally treaty obligation ఉన్నప్పుడు వాళ్ళు ఐసీజే కన్సెంట్ ఇచ్చారు అనుకోండి, దట్ మీన్స్ దట్ ఐసీజే డెసిషన్ వాళ్ళు అబాయిడ్ అవుతారు. దట్ ఈస్ ఫోరం ప్రోరాగేటం, దట్ ఈస్ అంటే ఇంప్లైడ్ కన్సెంట్ ఇస్తున్నట్టు అనమాట. సో దీస్ ఆర్ ద డిఫరెంట్ contentious jurisdiction. నెక్స్ట్ అడ్వైజరీ jurisdiction. కంటెన్షియస్ ఇస్ బిట్వీన్ స్టేట్స్. అంటే ఇప్పుడు మనం ఐసీజే ఉంది సార్, ఐడబ్ల్యూటీ ఉంది కదా, ఇండస్ వాటర్ ట్రీటీస్. సో దీస్ ఆర్ లైక్ ట్రీటీస్ వేర్ 2 స్టేట్స్ మధ్యలో గొడవలు అయినప్పుడు దే గో టు ఐసీజే. బట్ ఇన్ ఆర్ కేస్ ఇప్పుడు మొన్న ఐసీజే వాళ్ళు దే గేవ్ ఇన్ ఫేవర్ ఆఫ్ పాకిస్తాన్, బట్ వీ నెవర్ వెంట్ ఆల్సో.
Right.
మనం అసలు రిప్రజెంట్ కూడా చేయలేదు అక్కడ. We said the situation has changed and we don't want to get involved.
Yes.
We don't want to honor the IWT only. So next ఏంటంటే advisory jurisdiction, Article 65 to 68 of ICJ. Advisory is basically to issue advisory opinions on complex questions of law, which is basically for United Nations. United Nations or its related agencies ki, the agencies can ask for advice. Any advisory opinion is not binding the same way as contentious judgment, yet advisory opinions have found profound legal primacy and moral weight and often assist UN bodies in their functions and add to the political rationale. So these advisory are not binding, but basically it will help all these organizations which are under UN. So what are the powers and functions of ICJ? The ICJ aids in peaceful resolution of disputes and development of law. The ICJ has for the following powers: one, dispute resolution settlement only, adjudicating similar disputes between states as per Article 38. So basically, treaties, custom, general principles, subsidiaries, judicial decisions, and subsidiary and by subsidiary means, which is judicial decisions and teaching. Next is interpretation of treaties, offers authoritative interpretation of substantial aspects of international legal instruments. Third is determination of state responsibility, decides whether or not state has violated the obligations under international law. And this is what they have done in the IWT. Whether state has violated their obligations under international law. Their ICJ is now saying that India has to abide by IWT, and they have to come to ICJ if they have a dispute. But right now they have obligation to fulfill the IWT treaty. Repatriation orders can orders each party to restitution, compensation, or satisfaction. Progressive development of law. The ICJ through its ruling encounters counters constitutional law by clarifying the common law doctrine of complexity. Promotion of the rule of law lends credibility, legitimacy, and authority to legal certainty and compliance in international interaction. Enforcement and limitations. Binding judgment. Judgments according to Article 15 is binding only on parties and only in respect of the specific matter. No enforcement arm. The court, it must be clear, has no arm of enforcement. So, ఒకటి ఏంటంటే the judgments are binding when there are disputes. Second ఏంటంటే enforce చేయలేరు ఎందుకంటే it is between two different countries. They cannot enforce. So UN Charter Article 94, if a party fails to comply, other party may recourse to refer the matter to United Nations Security Council, the matter to be resolved. Hence, the action will be taken or may take subject to veto to permanent 5 members. So now we know the process. So what will Pakistan do now? They'll invoke the Article 94 and they'll refer the matter to ICJ. ICJ judgment తీసుకెళ్ళి United Nations Security Council ముందు పెట్టి బాబు వీళ్ళు ఇండస్ వాటర్ ట్రీటీని రెస్పెక్ట్ చేయట్లేదు, యుఎన్ సెక్యూరిటీ కౌన్సిల్ ఏమంటది? సో బేసికలీ ఇట్ ఈస్ అ వీడియో 5 permanent states. సో ద పర్మనెంట్ యుఎన్ సెక్యూరిటీ కౌన్సిల్ వాళ్ళు దాని మీద ఓటింగ్ చేసి వెదర్ ఇండియా తప్పు చేస్తుందా లేదా అని చెప్తారనమాట ఫ్యూచర్. Limitations of ICJ. Jurisdiction is subject to states' consent. The ICJ cannot adjudicate cases involved individuals and non-state entities. So it is important. Individuals and non-state entities. అంటే కంపెనీస్ కూడా వెళ్ళలేవు. కంపెనీస్ వెళ్ళి మాకు ఇక్కడ ఆయిల్ ప్రాబ్లం అవుతుంది, ఇది అవుతుంది, దే కెనాట్ డూ దట్. ఓన్లీ states can go. The ICJ lacks competent appellate jurisdiction over domestic or international tribunals. The ICJ does not have ability to initiate cases themselves, or in techno terms, sumoto. No, there is no sumoto cases in ICJ. Okay. So relevant cases, this is a very old case, Corfu Channel case, United Kingdom versus Albania. Basically, in this case, what happened is in 1949, Albania put a lot of mines in the sea. So which actually, and they didn't inform the because it was in international waters and they didn't inform the other countries like British, and British warships went through that mines and they were damaged. So UK went to the ICJ. ICJ said, yes, you are responsible because you did not notify the UK of the existence of minefields in territorial waters. The important thing is you have to write this territorial waters for violating the duty not to knowingly allow its territory to be used for acts contrary to the rights of other states. The judgment establishes the principle states have obligation to notify other states of dangers in territorial waters and reinforce the concept of state responsibility for acts or omissions within the territory causing harm to other states. Okay. The second one
So
is
this is within their territorial waters లో చేసినా కూడా they have to inform to others.
they have to inform. అంటే ఇది కొంచెం ఇప్పుడు వాడు మైన్ పెట్టిందే ఎవడో రావద్దని ఇన్ఫార్మ్ చేస్తే ఇంకా మైన్ పెట్టడం ఎందుకు సార్?
Of course,
కదా.
that is makes
Just the
sense.
hegemony of the Western ఇదంతా డామినేషన్ సార్ వెస్టర్న్ కంట్రీస్.
Only power.
అంత మించి ఏమి ఉండదు. Armed activities of territory of Congo, Democratic Republic of Congo versus Uganda. So in this significant case, the Congo was accused. Congo accused Uganda of military aggression and exploitation of natural resources. ICJ ruled that Uganda had violated the sovereignty and territorial integrity of Congo and breached the prohibition on use of force. So Uganda was held liable for human rights abuses and committed by its forces and for economic damage in the Congo. The court ordered Uganda to pay repatriations, reinforcing ICT jurisdiction. So basically, it's a standard case where Uganda went and uh, attacked Congo, and then they actually did a lot of human rights violations and then economic damage, for which ICJ gave a judgment saying that guys have to pay, and they were forced to pay on that. Last law, I just put one ICJ versus ICC. It's between individual states, so state responsibility, legal disputes. So, like ICC is more of genocide, war crimes, so crimes against humanity. Individuals ఎక్కువ చేస్తారు. ఇది legal basis is UN Charter. It's basically in Hague. Whereas ICC's legal basis is Roman Statute of 1998. Enforcement, no enforcement, ICC independent prosecution and arrest warrants. So ICG plays a pivotal role in promoting the rule of law in international affairs, reinforcing states' responsibility and providing peaceful dispute resolutions. Despite limitation of jurisdiction enforcement, its legal authority, jurisprudence, and interpretative role remains foundation pillar of contemporary international law. Okay, sir.
Fine.
Can you do the 9-10, sir?
Yes, sir. Is my voice clear, sir?
Yeah, clear, sir, clear. Yeah.
9th question. Treaties, formation, reservation, and the Vienna Convention on the Law of Treaties, VCLT. So this is not yet exams లో ఇప్పటి వరకు రాలేదా సార్ ఈ క్వశ్చన్? ఆర్ రిపీట్ వన్ మనం ఏమన్నా
ప్లీజ్ ఐ థింక్ నేను అక్కడ రాయటం మర్చిపోయి ఉంటాను, బట్
అదే సంథింగ్ మిస్ అయినట్టు, ఎందుకంటే నెక్స్ట్ క్వశ్చన్ ఈజ్ ఆల్సో రిపీట్ వన్ ఉంది.
this is actually repeat 2 times.
Two times. Okay.
You see this repeat 2 times. Diplomatic agents mode of acquiring is repeat 1 time.
Yeah.
Till 9 it is repeated 2 times.
Right.
I think ఇక్కడ సరిగ్గా నేను రాయటం మర్చిపోయినట్టున్నాను. 9, 10. బట్ ఆల్వేస్ మీకు ఈ ఇండెక్స్ లో అయితే కరెక్ట్ గా ఉంటాయి సార్.
ఎస్ అదే డౌట్ వచ్చింది, అంటే మన దాంట్లో నెక్స్ట్ క్వశ్చన్ కూడా రిపీట్ అని ఉన్నది, అంటే మధ్యలో ఇలా. ఫైన్, ఇట్ ఇస్ క్లియర్ సార్. It is repeated twice. Okay. A definition: a treaty serves as a formal international agreement concluded between two or more states or between states and international organizations, primarily in written form and governed by international law. Its particular designation, be it a convention, agreement, protocol, charter, covenant, or pact does not alter its fundamental character as a binding international instrument. The foundational legal framework for treaties is largely codified in the Vienna Convention on the Law of Treaties, which is VCLT 1969, a landmark instrument often referred to as the Treaty on Treaties, which entered into force in 1980. So treaties are basically it is between the countries, like మనం ఇప్పుడు అనుకున్నట్టు international water treaty, which between India, Pakistan, and we have between India and other countries also. Those kind of treaties, these are between countries, between organizations in different countries, like a military treaty or supporting other country military, those kind of things. The VCLT Article 6 to 25 outlines a structured multi-stage process for the formation of treaties, reflecting the complex interplay of state sovereignty and international cooperation. So there are some set of rules and regulations for all these treaties are given in Vienna Convention of the Law of Treaties, which is VCLT. Those are negotiation. The initial phase involves representatives of the prospective parties engaging in discussions to formulate the text of the treaty. Negotiations aim to achieve a mutually acceptable draft that addresses the objective of the agreement. Adoption of text. Once negotiations conclude, the participating states formally agree on the final content and wording of the treaty text. For treaties concluded at an international conference, adoption usually requires the vote of two-thirds of the states present and voting, unless a different rule is agreed upon. Authentication of text. This step formally establishes the text of the treaty as authentic and definitive. It signifies that the text is no longer subject to alteration. Authentication is typically achieved through signature of a referendum, a provisional signature subject to confirmation. In initialing by representatives, a preliminary indication of agreement, incorporation in a final act of conference, a formal declaration that the text is definitive, expression of consent to be bound. This is the crucial stage where a state formally indicates its willingness to undertake a legal obligation set forth in the treaty. Various methods exist for expressing consent. Signature. For some treaties, signature alone can signify consent to be bound if the treaty so provide, or if the negotiating states agree to this, or if the intention of the state to give that effect or to the signature appears from the full powers of its representatives or was expressed during the negotiation. A ratification, a formal act by which a state confirms its consent to be bound by a treaty already signed. This typically involves an internal constitutional procedure, example, parliamentary approval, and the subsequent deposit or exchange of instruments of ratification. Ratification allows states time to review the treaty domestically before committing legally. Acceptance or approval. These methods are similar to ratification and are used depending on the specific terms of the treaty. Accession. This method allows a state that did not participate in the negotiation or original signature of a treaty to formally become a party to it after it has been concluded and entered into force. Exchange of instrument constituting a treaty. In some bilateral treaties, the exchange of instruments, notes or letters between states signify consent to be bound. Entry into force. Intermediate, a treaty does not immediately become legally binding upon the expression of consent by a state. Its entry into force depends on its own provisions. Typically, a treaty specifies a particular date, the deposit of a certain number of instruments of ratification, acceptance, approval, or accession, the occurrence of specific event. Only upon entry into force does a treaty become operational and create binding legal obligation for the parties. Registration and publication. Under Article 102 of the UN Charter, every treaty and every international agreement entered into by any member of the United Nations shall, as soon as possible, be registered with the Secretariat and published by it. This provision aims to promote transparency in international relations and prevent secret treaties. A party to treaty not registered cannot invoke the treaty before any organ of the United Nations. So these are the kind of rules, how it is accepted, all those things are explained here. And next is reservations. A reservation, Article 19 to 23 of the VCLT. A reservation is a unilateral statement, however, praised or named made by a state when signing, ratifying, accepting, approving, or uh, acceding to treaty, whereby it purports to exclude or modify the legal effect of certain provisions of the treaty in their application to the state. Reservation allows states to join multilateral treaties even if they cannot agree to every single provision, thus promoting wider participation. The treaty expressly prohibits them. The treaty provides that only specified reservations, which do not include the reservation in question, may be made. In case not falling under the above, the reservation is not incompatible. The reservation is incompatible with the object and purpose of the treaty. This compatibility test is crucial as it prevents reservation from undermining the core essence or fundament of fund or fundamental goals of the treaty. Other states party to the treaty may react to reservation by accepting it. The treaty enters into force between reserving state and the accepting state, with provisions modified as per the reservation. Objecting to it but not opposing entry into force, the treaty enters into force between the reserving state and the objecting state, but the provision to which reservation relates to do not apply between them to the extent of the reservation. Objecting to it and opposing entry into force, the treaty does not enter into force between reserving state and the objecting state. Termination and suspension. Treaties once in force are generally intended to be durable, but circumstances may lead to their termination or suspension. The VCLT provides specific grounds. Mutual consent of parties. A treaty can be terminated at any time by the consent of all the parties, often through a new agreement. అంటే ఏదైనా న్యూ modification is done, then it can be modified and the old one will be nullified. Material breach. A material breach of a bilateral treaty by one of the parties entitles the other party to invoke the breach as a ground for terminating or suspending the treaty. For multilateral treaties, a material breach by one party allows other parties to unanimously suspend or terminate the treaty for specifically affected party to suspend it. Impossibility of performance. If the disappearance or destruction of an object indispensable for the execution of the treaty renders performance impossible, a party may invoke this as a ground for terminating or withdrawing from the treaty. Fundamental change of circumstances. This doctrine allows a party to terminate or withdraw from a treaty if there has been fundamental unforeseen change in circumstances that constituted an essential basis of the consent of the parties to be bound by the treaty, and the effect of that change is to radically transform the extent of obligation still to be formed under the treaty. This ground is invoked restrictively. Emergence of a new preemptory norm of general international law, just cognized. If a new peremptory norm, a fundamental overriding principle of international law from which no derogation is permitted, emerges, that is in conflict with an existing treaty, that treaty becomes void and terminates. Basically, the termination and suspension or international water treaty between India and Pakistan is the best example. And apart from that, different kind of termination methods. So relevant case laws: Qatar versus Bahrain, jurisdiction and admissibility. This case concerning a dispute over maritime boundaries and sovereignty over islands highlighted the flexibility of the definition of an international agreement under the VCLT. Bahrain denied that minutes of the meeting and the and exchanges of letters with Qatar constituted a binding international agreement. The International Court of Justice, applying VCLT principle, meticulously examined the terms and circumstances of these exchanges. The court ruled that these informal instruments, despite their designation as minutes, clearly evinced an intention by the parties to create a legal obligation. This landmark decision reaffirmed that the form of an international agreement is not determinative of its legal character, rather, the intent of the parties to be bound is paramount. It underscored that even instruments less formal than a full fledged treaty can create a binding obligation if they demonstrate a clear intention to be legally bound. So, between Qatar and Bahrain, they have written an agreement and between multiple letters, but latter it is not honored. When Bahrain went to court, ICJ, then they have said this can be treated as minutes. And AIG Capital Partners, a Republic of Kazakhstan. This case originated as an ICSID arbitration involved an investment dispute under bilateral investment treaty between the United States and Kazakhstan. AIG sued Kazakhstan alleging extra exploitation of its investment, expropriation of its investment, and sought to invoke the BIT's arbitration clause. Kazakhstan challenged the jurisdiction partly on the basis of reservation clauses within the treaty. The court, applying principle derived from BCLT, particularly concerning treaty interpretation and the effect of reservation, upheld the jurisdiction. It emphasized that dispute resolution mechanism within the treaties, including consent to arbitration or binding obligation. Furthermore, the court reiterated the principle that the reservation clauses must be interpreted narrowly to ensure they do not unduly undermine the object and purpose of the treaty, particularly in the context of investment protection. This case illustrative how the VCLT's principle are applied by domestic courts when interpreting and enforcing international treaties, especially those with specific dispute settlement provisions like BIT, bilateral investment treaty. Anything do you want to add, Vinny?
Yeah, sir. Only thing is for the IWT thing, the what India's stance is this fundamental change of circumstances. Earlier circumstances when we did IWCT is completely different from what we did and the termination. So we are quoting that fundamental change in circumstances
Yes.
termination clause. So Bahrain and Qatar and Bahrain, what the issue is ఏంటంటే, see there is a maritime boundary dispute between both the countries, but what's happening is uh, they didn't have an agreement. So if you see the thing, there is a dispute between Qatar and Bahrain regarding these islands.
Okay.
You can see the map now, sir. Yeah.
Yes,
So
yes.
so I mostly ఇందులో ఏంటంటే you look at the images, it becomes easy, sir. So they had meeting minutes, various meeting minutes saying that we'll do this, we'll do that, and the issue is still going on. It's not like the issue has ended. Recently also
Okay.
Bahrain. So this was in 2017. Sir. So the whole problem is basically from 1994. This problem is going on, but the court said that the meeting minutes can be clearly converted into an agreement, international agreement. Based on that only, we'll take a call. Okay, so why we are quoting this case is basically saying that international agreement ledu, but basically applying the international court applied the VCLT principles and examined the terms and circumstances of exchanges, and based on that they said that it forms loosely forms an international agreement, based on which you guys need to do this. The second one is ICSID is basically exit arbitrations are basically bilateral treaty arbitrations, which is uh, done by World Bank. Hmm. Yeah, so exit is basically, sorry, World Bank. There is arbitration group.
SCJ. Yeah.
World Bank lo MEGA untadi. Exit is not
Mm.
part of World Bank, uh, which is basically World Bank gives a lot of lawyers
Mm.
to fight. Um, the whole point in it, how does a company fight against a country? Because it's not
Mm.
easy, right? So
Yes.
AIG went and invested according to a bilateral treaty between US and Kazakhstan. In
Mm.
Kazakhstan, invest చేశారు వాళ్ళకేవో issues వచ్చాయి.
Mm.
Kazakhstan says nothing is binding and obligatory, get lost. But they have
Mm.
investment, right? So
Yes.
they went to sit for resolving. Okay. So because ఇప్పుడు it is a company versus a state కదా. So
Yes.
how do we deal? So the courts
Mm.
apply the VCLT principle. So
Mm.
actually, what we are learning is if there is no agreement between two states,
Mm.
what validates is that Vienna Convention of Law of Treaties, VCLT 1969,
Mm.
because it has an authoritative framework largely codifying customer international law governing the conclusion, entry to force, application, interpretation, amendments, and treaty of organization. So ఎక్కడైతే అగ్రిమెంట్స్ లేవో the VCLT stands tall, and
Mm.
based
Mm.
on that only the courts have given decisions on it. So that's what is highlighting in both the cases.
Fine. Fine, sir. Thank you.
Yeah, yeah.
Detailing explain చేశారు. So I will move to key principles. The Vienna Convention on the Law of Treaties 1969 stands as the authoritative framework largely codifying customary international law governing the conclusion, entry into force, application, amendment, and termination of treaties. Treaties become legally binding upon states only upon their express consent to be bound and their subsequently entry into force adhering to the principles of pacta sunt servanda. Agreement must be kept. Reservation provide essential flexibility, allowing states to join multilateral treaties while excluding or modifying the application of specific provisions, provided these reservations are compatible with the fundamental object and purpose of the treaty. The termination or suspension of treaties is permissible only under specific well-defined grounds recognized by international law, such as mutual consent, material breach by a party, or impossibility of performance, or a fundamental change of circumstances, ensuring the stability and predictability of international legal obligation. Okay, that concludes this. Next, I will move to diplomatic agents question. This is repeated once in 2022 November. De- Definition. A diplomatic agent is an official representative duly authorized by sending state to conduct official relations with the receiving state. These agents, along with their mission, are afforded specific rights, protections, and exemptions known as diplomatic privileges and immunities, which are crucial for their effective and independent performance of their functions. The legal framework governing these aspects is primarily codified in the Vienna Convention on Diplomatic Relations, VCDR 1961, which largely reflects and elaborates upon pre-existing customary international law. Key privileges and immunities under VCDR. The VCDR establishes a comprehensive regime of immunities and privileges designed. Venu sir, can you change the screen to? I'm reading from the book, but if somebody is
Right. Key privileges, I guess.
uh, key privileges, but I can see the screen of only that Qatar map.
Oh, okay, okay. Sorry. I
Hmm.
forgot to change to this.
Oh,
Okay, sir.
yes, sir.
Oh,
So
okay,
key
thank
privileges and immunities under VCDR. The VCDR established a comprehensive regime of immunities and privileges designed to ensure the efficient functioning of diplomatic missions and prevent interference by the receiving state. Personal inviolability. Article 29, the person of a diplomatic agent is inviolable. This is the cornerstone of diplomatic protection. They cannot be subjected to any form of arrest or detention. The receiving state has a strict obligation not only to refrain from infringing upon the diplomat's person, but also to take all appropriate steps to prevent any attack on their person, freedom, or dignity. This includes protection from harm by private individuals as well as state officials. Immunity from jurisdiction. Article 31. A diplomatic agent enjoys immunity from the criminal jurisdiction of the receiving state at all times. They are also immune from its civil and administrative jurisdiction with specific narrowly defined exceptions. An action relating to private immovable property situated in the territory of the receiving state, unless the agent holds it on behalf of the sending state for the purpose of the mission. An action relating to succession in which the diplomatic agent is involved as executor, administrator, heir, or legatee as a private person and not on behalf of the sending state. An action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside their official function. It is crucial to note that immunity from jurisdiction does not imply impunity. A diplomat remains subject to the law of the sending state. Law of the sending state, but not receiving state. Yeah. Inviolability of diplomatic premises. Article 22. The premises of the mission, embassy, chancellery, etc. are inviolable. Agents of the receiving state are prohibited from entering them without express consent of the head of the mission. The receiving state is under special duty to take all appropriate steps to protect the mission premises from any intrusion or damage and to prevent any disturbances of the peace of the mission or impairment of its dignity. The inviolability extends to the furnishings, property, and means of transport of the mission. Freedom of communication. The receiving state must permit and protect free communication on the part of the mission for all official purposes. This includes the use of diplomatic couriers, diplomatic bags, and coded messages. The diplomatic bag, which must be clearly marked, cannot be opened or detained. It can only contain diplomatic documents or articles intended for official use. This ensures the secure and unhindered transmission of sensitive information between the mission and its sending state. Exemption from taxes and duties. Article 34. Diplomatic agents are generally exempt from all dues and taxes, personal or real, national, regional, or municipal, with certain exceptions. Indirect taxes normally derived from sources in the receiving state. They are also exempt from customs duties on articles for their official use and articles for their personal use. Family members, Article 37. The privileges and immunities generally extend to the members of the family of a diplomatic agent forming part of their household, provided they are not nationals of the receiving state. This ensures the comprehensive protection of the diplomatic household. So basically, these are the privileges and immunities for diplomatic agents, like personal. They for the their premises, nobody should enter their premises without their permission. The person is immune from all criminal or any other activities in the receiving state, and what kind of powers they have in receiving state about that. And their family members, their baggage, screening, etc., are prohibited, etc., discussed here in this section. So next, waiver of immunity, Article 32. Diplomatic immunity is not a personal right of the diplomat, but a functional immunity granted to the sending state to ensure the effective performance of the mission's function. Therefore, only the sending state has the authority to waive the immunity of its diplomatic agent. Such a waiver must always be expressed, meaning it must be clearly and unambiguously stated. It cannot be implied. A waiver of immunity from jurisdiction in respect of civil or administrative proceedings does not imply a waiver of immunity from execution of the judgment, for which a separate express waiver is required. Persona non grata, Article 9. The receiving state retains a significant unilateral power in managing diplomatic relations. It may, at any time and without having to explain its decision, declare a diplomatic agent persona non grata, an unwelcome person. Upon such a declaration, the sending state is obliged to either recall the person concerned or terminate their functions with the mission. If the sending state fails to do so within a reasonable period, the receiving state may refuse to recognize the person concerned as a member of the mission. This power serves as a critical safeguard for the receiving state, sovereign interest, and its ability to maintain effective relation with the foreign mission. How this immunity can be waived, and if a person is doing any wrong things in the receiving state, how they can be removed. These are explained here. Relevant case laws. United States diplomatic and consular staff in Tehran, United States versus Iran. This seminal case concerned the seizure of the United States embassy in Tehran by Iranian militants in 1979, resulting in the detention of American diplomatic and consular staff and the prolonged occupation of the embassy premises. The International Court of Justice unequivocally held that Iran had violated multiple fundamental obligations under the Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations, including the inviolability of diplomatic premises, the personal inviolability of diplomatic and consular staff, and the inviolability of the diplomatic archives and communication. The court emphasized that the receiving state, Iran, was under a continuous obligation not only to refrain from attacking the diplomatic mission itself, but also to actively protect it from any attack by private individuals. This case stands as a powerful reaffirmation of the absolute and non-derogable nature of diplomatic immunity and its essential role in the conduct of international relations. Actually, this was a landmark case, we can say, where Iran has breached Vienna Convention as per ICJ, and ICJ straightforward give a ruling that it's Iran's mistake. They are not able to protect, and in fact, they breached all the law of diplomatic immunity.
Yeah, there's a movie also that is made how they
Mm.
move the people out of that country,
Yes.
posing as actors. Movie this no money.
Mm. So how US protected their diplomats here.
Hmm.
So another case is Republic of the Congo, Belgium arrest warrant of 11th April 2000. While not solely about persona non grata, this case touched upon the broader principle of immunity of a sitting foreign minister, which is directly analogous to diplomatic immunity. Belgium issued an international arrest warrant for the Congolese foreign minister, Mr. Erodia, for alleged war crimes. The ICJ found that a serving foreign minister enjoyed full immunity from criminal jurisdiction in other states, even for alleged serious international crimes during their tenure. The court's reasoning highlighted the necessity of such immunity for the effective performance of official functions and the maintenance of international relations, reinforcing the functional basis of diplomatic immunity. While this case dealt with a higher ranking official, his underlying principles strongly support the rationale for the inviolability of immunity of diplomatic agents as outlined in the VCDR. Anything you want to add, Venus, here in these two
Yeah,
cases?
అంటే ఎగ్జిస్టింగ్ ఫారిన్ మినిస్టర్ మాకు నచ్చలేదు వాడు వార్ క్రైమ్స్ చేశాడు అంటే ఐసీజీ సైడ్ నో ఎగ్జిస్టింగ్ ఫారిన్ మినిస్టర్ ఎంజాయ్స్ ఫుల్ ఇమ్యూనిటీ ఫ్రమ్ క్రిమినల్ జ్యూరిస్డిక్షన్ ఎనీ అదర్ స్టేట్స్. సో వాడిని ఏం చేయలేము అని చెప్పారంట యాజ్ పర్ విసిడిఆర్.
ఓకే ఓకే. But recently there is one story of one country, maybe not related. Okay, yeah, I'll move to the summary principle. The diplomatic immunity is not a personal privilege but a functional necessity designed to enable diplomatic agents to perform their duties effectively and independently, free from coercion or interference by the receiving state. Host states are under strict international legal obligation to respect and actively protect diplomatic missions and their personnel, even in times of political tensions or conflict. వాళ్ళ కంట్రీలో ఏ కాన్ఫ్లిక్ట్ ఉన్నా కూడా ఇట్స్ దేర్ రెస్పాన్సిబిలిటీ టు ప్రొటెక్ట్. While broad diplomatic immunity is not synonymous with impunity, the sending state can waive immunity and the receiving state retains the powerful right to declare a diplomat persona non grata, compelling their removal. Furthermore, a diplomat can be prosecuted in their own sending state. So, while state lo matrame he has to be prosecuted, but not on receiving state. The Vienna Convention on Diplomatic Relations 1961 is universally regarded as the authoritative codification of customary international law and diplomatic relations, making its provisions largely binding on all states regardless of formal ratification. Concludes this question. So, final question you want to complete that? చేసేద్దామా? ఓకే, ఇది చేస్తే
చేసేద్దాం సార్, అయిపోద్ది కదా.
యా కంప్లీట్ అయిపోతుంది పార్ట్ బి.
Yeah. Sure, 1 minute. So basically, this is the chapter. అంటే ఇప్పుడు ఇందాక మనం సక్సెషన్ ఇవన్నీ నేర్చుకున్నాం. దిస్ ఇస్ సార్ 1 minute వాటర్ రాస్తుంది.
Yeah.
Yeah, sorry sir. So this is a mode of acquiring territories. For example, existing territories ఉన్నప్పుడు వేరే కంట్రీస్ ఆ టెరిటరీస్ అక్వైర్ చేసినప్పుడు వాట్ ఆర్ ద రూల్స్ అండ్ రెగ్యులేషన్స్. For example, Alaska was acquired from USSR to America, right?
Yeah.
So what are the modes and what are the international rules that apply? So in public international law, acquisition of territory refers to legally recognized methods by which a sovereign state may gain legitimate title and consequently exercise sovereignty over specific geographical area. For such acquisition to be valid in international law, it requires a combination of elements, including legal entitlement, effective peace control, and in certain contexts, validation through international recognition. The traditional modes have evolved significantly with the development of international law, particularly after the advent of United Nations Charter. One is a mode of territorial acquisition. The recognized mode of acquiring territory are one, occupation. This mode applies as terra nullius, land belonging to no one, meaning territory that is not under the sovereignty of any state. To establish sovereignty through occupation, two essential elements must be present. One is animus occupendi, intention to acquire sovereignty. The state must clearly demonstrate its intention to act as sovereign. Corpus possession now is. This involves the actual existence of states' function over the territory, such as administrative acts, legal measures, or judicial actions. The level of effective control requires varies depends on nature of territory. Example, historical claims or uninhabited islands or newly discovered lands through the new existence of territory is extremely rare. Second one is accretion. Accretion is a process of acquiring new territory through slow and gradual natural geographic process. This involves the natural expansion of states' existing territory, often due to geological, hydrological phenomena. Example, the formation of new land by volcanic activity, the gradual deposit of sediment along riverbanks, or the recession of a coastline. Ownership attaches automatically to adjoining coastal line, requiring no specific act of occupation or declaration. The other one is secession. Secession involves a formal transfer of territory from one state to another state through a treaty. This is a consensual process reflecting the will of both the transferring and acquiring state. The treaty must be valid concluded between sovereign state adhering to the principle of VCLT. Cessation can occur through various forms such as sale, exchange, or through part of peace settlement. The fourth is conquest. Historically, conquest referred to military acquisition of territory followed by formal annexation. However, with the evolution of international law, particularly 20th century, this method is now illegal. Next, prescription. Prescription involves acquisition of territory by state through peaceful and uninterrupted possession and exercise of sovereign over geographical area for a prolonged period with the acquisitions of the overall sovereign. It is distinct from occupation as it applies to territory that was originally under the sovereign of another state. Effective and continuous exercise of sovereignty. The acquiring state must have actively administered the territory. Then the original sovereign must not have actively protested or attempted to reclaim the territory through force. Prolonged period, while no fixed duration exists in international law, the period must be sufficient to infer acquiescence. Absence of protest. Crucially, the overall sovereign silence or failure to protest against acquiring states' exercise of authority is interpreted as tacit consent or acquiescence. Okay, adjugation territories can be acquired or confirmed through binding judicial decision or arbitrary award when states submit a territorial dispute to international court or arbitrary tribunal. The resulting judgments or award legally settles the question of sovereignty over the dispute area. Example, the ICJ judgments in boundary disputes will have to determine the legal title of territory between the disputing parties. Okay, there are two case laws. Island of Palmas case, US versus Netherlands. The seminal arbitration case involved a dispute over sovereignty of island of Palmas in the Dutch East Indies. The United States claimed sovereignty based on the secession from Spain, which had discovered the island. Netherlands argued for their sovereignty based on the continuous peaceful display of authority over the land since the 17th century. Arbiter Max Huber famously ruled in favor of Netherlands. He emphasized that the title of the acquisition territory was not followed by actual continuous peaceful display of states' functions and international law, no more than inchoate title. The case established that the effective and continuous display of sovereignty is paramount and trumpets more historical claims like discourage secession if the transferring state does not exercise effective control. So in this case, what happens is United States island Spain దగ్గర కొనుక్కుంది. బట్ నెదర్లాండ్ సైడ్ మాకు 17th century మ్యాప్లోనే ఐలాండ్ మా దాంట్లో ఉంది కాబట్టి అది మాదే. స్పెయిన్ మాకు చెప్పకుండా అమ్మేశారు అని. So the ICJ ruled in favor of Netherlands, saying that in order to have the title, it has to be continuous, actual, and has to have a peaceful display of states' functions. So in this case, effective control was given back to Netherlands. The other one is Clipperton Island case, France versus Mexico. The arbitration concerned sovereignty over uninhabited island in Pacific Ocean. France claimed sovereignty based on the Act of Formal Occupation 1858, which indeed a declaration of publication in Hawaii. Mexico argued that it always considered the island its territory. The arbitrator King Victor Emmanuel III of Italy ruled in favor of France. He found that for remote and uninhabited, the degree of effective control requires for occupation is less stringent than for more accessible or populated areas. He stated that actual and not merely nominal taking of position must be manifest in some formal way and not be left to inference. Because వాళ్ళ ఐలాండ్ వాళ్ళదని చెప్పారు బట్ దే హ్యావ్ నాట్ ఇన్హిబిటెడ్ అండ్ ఇట్ ఈస్ ఫార్ అవే ఫ్రమ్ their region. That's why they favored in terms of France. In this specific context, the formal declaration and symbolic act of sovereignty were deemed sufficient to constitute effective occupation of uninhabited island and no other state had exercised adverse control. The case clarified the level of effectiveness for occupation varies depends on the nature of territory and that the manifestation of intent can establish sovereignty in appropriate circumstances. So key principles ఏంటంటే ఎఫెక్టివ్ కంట్రోల్ ఉండాలి. బేసికలీ మన ల్యాండ్ యాక్ట్లో పొజిషన్ ఉన్నట్టు ఇక్కడ కంట్రోల్ ఉండాలి. The use of force to acquire territory is unequivocally illegal. Force use చేయలేము. Recognition by other states is also important. And international courts and tribunals frequently apply additional principles like possessidus juris, which dictates that newly independent states inherit the colonial administrative boundaries that existed at the time of their independence, principles of equity to achieve just and practical outcomes. Ante sir.
Yeah.
So we are done.
Conclude. Done. That question part be completed.
Okay sir, part B completed. We'll tomorrow meeting approach చూసుకొని దాన్ని బట్టి